And to help us further distill the coroner's inquest system and some of the changes, we're joined by the assistant coroner in Clark County, John Feudenberg. John, thanks for being here.
Thank you, Randy.
Okay, John, first we'll talk about some of the changes here to the coroner's inquest system in just a second, but I think most of all, this has always been an open system. I think maybe the residents don't really understand that, but in most other jurisdictions, quite often any officer-involved death, any decisions are made behind doors, right? So this is a completely open system.
You're very correct. In most jurisdictions across the country, it's either the process is done by the use of the grand jury, which is not open to the public, or the DA just makes the decision on whether or not to go forward with charges. So we have, other than King County, which is the Seattle area, we have probably one of the most open and inclusive processes in the United States.
And I know you're very proud of the work your office does, and of course it has coroner's inquest right in the title. Just kind of describe what some of the duties you or the folks in the coroner's office do in the coroner's inquest system.
Sure. Well, as you know, we do an independent investigation into the death of an individual that's caused by a law enforcement officer. So our first step is to do an independent investigation. From there, we'll call an inquest. And at that point, once an inquest is called, we really are only responsible for facilitating the process. We don't have a major role once the inquest gets started.
Referee, judge, what would you kind
of?
No,
really neither. We assign or we request the chief JP of the particular township to assign what's referred to as a presiding officer, and it's one of the judges in that particular township where the incident occurred. And once we meet with the judge that's going to be assigned to the case and serve as the presiding officer, a lot of the responsibility falls on the judge, and we facilitate the process and we help the judge through that process. But really, we're not a referee, we're more of the facilitators, and we take care of most of the logistics throughout the process.
Okay, perfect. Let's back up 6 or 7 months ago to when the Board of County Commissioners convened the Coroner's Inquest Review Panel. I know yourself and/or Coroner Murphy attended all the meetings and/or sat on the panels for all these, and you had pretty much all the stakeholders involved in this this sometimes controversial system. How do you think those meetings went? What just kind of give us?
You know, they went very well. We had some very productive conversation. There was, of course, some disagreement, but it was all very reasonable disagreement. And overall, we didn't have 100% consensus, but we certainly had an agreement on most aspects of the process. And those recommendations that were created by the panel went forward to the county commission, and they adopted most of the recommendations as they were crafted and made some minor modifications. And here we are with the new system.
Let's talk about, I guess, maybe the first one is the ombudsman, the addition of an ombudsperson to act on for the public and or for the family. Is that the ombudsman? How is that going to change your role or change the kind of the process from your perspective?
You know, that is the major change in the new process is the introduction of the ombudsperson. And what that's going to mean is the ombudsperson is going to be asking questions to the witnesses on behalf of the family and the public. So in the past, under the old county ordinance, the family or the interested parties involved in the process could introduce written questions to the witnesses. Well, that's no longer going to be the case. There will be no written questions. You know, in the past we've had over 1,000 written questions submitted by the interested parties, which certainly made it a little more lengthy. Now we're going to have the ombudsperson who will question the witnesses in lieu of the handwritten questions. So we think it'll streamline the process and make it a little more, make the questions more focused and more purposeful.
I think the pool of ombuds people that we have so far is kind of the who's who. We've got a great number of top-notch attorneys here in Las Vegas that are doing this. And I know part of the process they will also be involved is in your pre-inquest hearing. There's usually going to be a couple of those hearings. Just kind of walk us through that procedure.
Sure. Well, what will happen is the first meeting will be called the initial pre-inquest conference, and all of the interested parties will be included in that process and be able to participate. The interested parties will include the ombudsperson, the decedent's family's attorney, if there is one, the officers that were involved and their attorney, and the district attorney's office, and of course we'll be involved. So the presiding officer will oversee that process, and in the initial pre-inquest conference we'll discuss things like the preliminary witness list, what types of evidence that are going to be introduced, and just basic logistics of the process. Then what we'll do from there is we'll schedule within 30 days. The ordinance requires us to have the final pre-inquest conference completed within 30 days of the initial pre-inquest conference, and there we'll finalize the witness list. We'll talk about the interrogatories, which we'll come back to. That's replacing the verdict, and I'll tell you a little bit more about that in a minute. And really finalize the evidence that's going to be that each party is going to be able to introduce into the process.
And we've had one of those meetings on a case we don't want to get too deeply involved in right now, but how was the atmosphere? How was that kind of helped the process from what you've seen before and just based on this this most recent case, John?
You know, we did. You're right. We did have the initial pre-inquest conference for our first case just 2 weeks ago. And it went well. It went very well. We learned a lot from it. You know, you read the ordinance and you prepare all you can, but you never know what's going to happen based on how the interested parties are going to bring the issues forward. And everybody was very cordial, and it was very productive. We learned a lot, and at the same time we got a lot done, and we're now preparing for the final pre-inquest conference.
And what do you envision taking place in that one? And that one, as you say, will be taking place by statute within a month, within 30 days of the actual inquest.
Right. It's scheduled for June 5th, actually, and it's not open to the public. It's only open to the interested parties and their attorneys and their representatives. So what will happen there is we'll finalize the witness list. We'll discuss the interrogatories, and we will discuss the final list of evidence and documents that will be able to be reviewed during the inquest.
Typically, since certainly in the past few years, we've averaged 8 to 10 or 12 of these coroner's inquests per year. Now, I guess with these coroner's inquests being on hiatus for 6 or 7 months, there must be a bit of a backlog. What's going to happen with those cases?
There is a backlog. We actually have 11 cases that are pending inquest currently, and as you know, we're working on the first right now. So we're really going to just wait to get through the first inquest, see how everything goes. We're certainly going to learn a lot about the process during the first inquest. And at that point, we're going to start scheduling the backlog, and we hope to get through them as soon as our resources allow.
You touched on the now no verdicts will be rendered. At one point it was either justified, excusable, or criminal, but now the folks that will be that will be tasked with sitting on and they're not even a jury anymore, they're an inquest panel. What type of voice will they have, or what will you do with the result, whatever that might be?
Well, what used to be referred to as the jury will now be referred to as the coroner's inquest panel, and they will still be able to ask questions of the witnesses, so they're able to question the witnesses, as are the interested parties, and they don't have to do that in writing. They can do that verbally. So in addition to asking questions of the witnesses, they're going to develop the answers to the interrogatories. So the interrogatories, what the purpose of them will be is to deal with fact, not guilt or innocence. And that's the other major change of the new process. Originally, the purpose of the coroner's inquest was to be an investigatory, fact-finding proceeding, not to determine whether or not guilt or innocence should have taken place. So the new ordinance really reflects the true meaning of, or the intent of, the inquest. So through the interrogatories, the jury, or what used to be referred to as the jury, now referred to as the coroner's inquest panel, will determine the questions of fact, but they won't deal with whether or not the officer's actions were justified, criminal, or excusable.
Why do you think this entire process it's controversial in nature? Is that just a simple answer to a simple question?
Well, it's controversial because there's a death involved, and anytime you have a death involved in a situation, it's going to receive a lot of attention, and certainly it's going to be controversial at times. So the importance of our process is that the public is going to be able to hear the evidence of the case, and they're going to be able to understand why the officers took the actions they took, and they'll really learn a lot about the process. They'll learn about procedures of law enforcement, and they'll have a good understanding of what actually took place during the process.
And whether it's opening up the hearings and or televising them as we do now on Channel 4, open and transparency. I mean, that's what it's all about, isn't it? This is our responsibility to the public?
Absolutely, and it doesn't get any more open and transparent than broadcasting them on our Clark County Channel 4. So we're certainly accomplishing being open and transparent by broadcasting the entire process on cable television.